Okay, we're at 9 a.m. We have several participants that have come on here with us. Welcome everyone who's here. I think we have some more people that will be joining us as well. I'm Dana Lancelotti. I am the president of the New Jersey Restaurant and Hospitality Association. We're happy to have you here today to learn some great things from Mendelbaum and Barrett, who are here with us today. This is our New Jersey Restaurant and Hospitality Association webinar series, and we are excited to be able to give you great information that'll be beneficial to you for your business. Right now, I am going to introduce our guests, our webinar hosts today. I want to first mention that everyone who's here watching, please use the chat box for questions. We're not going to be taking questions throughout the webinar presentation. We'd prefer that you please go into the chat, write your questions, and then when we get to the Q&A section, Alyssa Alarcon, who is our Director of Marketing and Communications, is going to field those questions, and Gary and Brent will be able to address them. All right, so without taking any more time, I want to move forward, and I will give you a bio on both of our presenters today. So Gary Young is a partner in Mendelbaum Barrett's corporate and ERISA practice groups, where he utilizes his lengthy legal experience to provide clients with a unique perspective on ERISA, tax, and employment matters. He concentrates his practice on ERISA compliance, employee benefits, executive compensation, and employment law compliance. Since 1996, Gary has served as the general counsel for the New Jersey Restaurant and Hospitality Association and is often called upon to speak on behalf of issues affecting the entire restaurant industry in New Jersey. Brent Pullman is a partner in Mendelbaum Barrett's labor and employment practice group. Brent has extensive experience representing employers in complex civil litigation, including civil rights actions, whistleblower claims, contract disputes, wage and hour cases, and other types of employment disputes. He regularly represents clients in federal and New Jersey state courts, in addition to appearing before administrative agencies, including the Equal Employment Opportunity Commission, the Office for Civil Rights, the New Jersey Division of Civil Rights, and the New Jersey Department of Labor. Once again, we're very happy to have Gary and Brent here with us. I will give the floor to you. Thank you so much.
Okay, and good morning, everybody. Certainly have appeared before the association many times over the years, and I think this is the first time I'm doing a webinar with the association, and I think that this has just been a tremendous development in terms of our ability to communicate with our members and to bring to them resources which are in this very complex legal environment that we live in, very much needed. So, you know, I thought about the title. Of course, Benjamin Franklin came up with time is money, but I think that ultimately that's really what we're talking about today. Ultimately, you have people working for compensation, and the manner in which they're compensated and the rules and regulations that surround that are really quite complex. And the other thing that we should all keep in mind is that it's a moving target. The law advances down the road, and whatever was true today isn't necessarily going to be true tomorrow. But I would say that the one disturbing development or aspect of this that I see more and more is that when they pass new laws, it's always with some provision for suing the employer and recovering attorney's fees and punitive damages and other things like that. So like that or not, ultimately the message has to be that it's important that you understand the risks, okay? And this slide just simply makes clear business is the art of taking risks. And if you are unaware of those risks, you're not going to be managing those risks very well. And ultimately, you need a team around you to help you to make your way through the maze of the many complexities and ultimately not make mistakes if you can help it. So we're going to talk about minimum wage in a moment, but ultimately there's a basic requirement here, which is one, you have to assess what is your relationship with the person that is performing services for you. Are you the employer? Are they the employee? Are they an independent contractor? What are the minimum requirements that the law imposes? So we all should understand that you must pay employees for all hours worked, which means that you have to keep track, for the most part, keep track of that time and pay them not less than the minimum wage. And one of the things that I see more and more reference in the news and everything is there seems to be a trend in the law to eliminate the tip credit, for example, is that there's many times a reference to that restaurant employers pay a sub minimum wage to their employees. That is absolutely incorrect. Okay. Your obligation, as with all employers, is that you must pay the minimum wage or greater for all hours worked. But as we'll get into a little later, we can take a tip credit to help arrive at that goal of paying at least the minimum wage. And of course, in many instances, our employees receive far more than the minimum wage, but the politicians would have other people in society believe otherwise. Okay, so who sets the minimum wage? That's really illustrates another aspect of employment law, but in particular wage and hour law, because you ultimately in the United States of America have at least two sovereigns. Okay, clearly the federal government in many instances, and then the state of New Jersey, and then you might actually have minimums that are set by cities. New York City is very, very good at imposing their own set of laws and they keep upping the ante in terms of what are the minimums. So ultimately, you have to understand that when we talk about a minimum wage, for example, we're not just talking about the federal minimum wage, which is $7.25. We also have to be aware of and comply with the state minimum wage, which is $13 an hour. And so people tend to think, well, the federal government is the supreme ruler in the land. And in many instances, that's true. But in the particular instance of this, the Fair Labor Standards Act is tied into the Commerce Clause of the Constitution. And in order to be subject to federal law, your enterprise has to have a gross of $500,000 or more. But also, you should understand that the federal government sets, if it applies to you, you're subject to its jurisdiction, they're going to set the minimum, in this case, 7.25. But the state of New Jersey always has the right to set a higher minimum, and they have. Okay, so that's why we have a $13 minimum wage. Okay, so now we're going to talk about employee classifications. And we have various classifications, ones that you're generally familiar with. So we have, is this person an employee or are they independent contractors? And we'll get into independent contractors in a little bit. Are they full-time, part-time? Now, what is full-time? Sometimes the law will set a minimum requirement for full-time. So in the case of the Affordable Care Act, if you have worked 30 or more hours a week, you are considered a full-time employee and subject to the application of the law. You have a concept of exempt and non-exempt. Now, what does that refer to? Well, it simply means that if you're exempt, you don't have to pay that person overtime. If they're not exempt, and generally speaking, assume many fall into that category, then if they work more than 40 hours in a work week, they have to be paid time and a half their regular rate. And that regular rate cannot be less than the minimum wage, but frequently is in excess of that. You also have a concept of a salaried employee and an hourly employee. Clearly, if we say they're non-exempt, that means that you have to pay them overtime. Those people are going to be hourly workers. So you have to keep track of their hours. You have to set their rate, and then the overtime rate will be time and a half that amount, or sometimes more than that, depending. You can always pay people more than the minimum, but you can't pay them less than the minimum. And then, of course, as we were referencing just before, we in the restaurant industry, you have tipped employees that is unique to this industry for the most part. So there's a lot of things going on there. And ultimately, with this whole stew of terms and conditions that the government set down for you, ultimately you, the employer, are responsible with compliance. And I would say that one of the things I've seen time and again is that an employer terminates an employee The employee goes running down to the Department of Labor, New Jersey typically, and before you know it, you have an audit, and now you're learning for the first time that you didn't do this right or that right, and that can have some severe consequences as a result. So I would just urge everybody, it's incumbent upon you, it's expected of you, it's mandated legally that you know the law and that you apply it properly. And that's a big job. On top of that, you have to set the audit trail for your practices. So keeping track of the hours. How many hours did so-and-so work 3 years ago? Well, you're supposed to be able to answer that question. You have to keep those records for a period of time. So ultimately, the onus is on you. And if you misidentify somebody and you say, oh, you're exempt and I don't have to pay you overtime, when in fact, as a matter of law, you should have been paying overtime, there's going to be a consequence to that. So Brent, I think you're coming up next.
So we're going to start this conversation, employee classification, by talking about the employees versus independent contractors. You know, oftentimes there's certainly a financial benefit for both the worker and the employer to classify an individual as an independent contractor for tax reasons, for benefit reasons. It reduces the costs to the employer, and it enables the employee, the worker, to have more control over their financial situation and their tax payments. However, misclassification, as Gary's going to talk about in more detail later, can lead to significant liability for your business and in principals individually. So it's important that we understand who can we classify as an employee, or who do we have to classify as an employee, and who can we classify as an independent contractor. Different states use different tests or modified versions of different tests to make this determination. In New Jersey, we use what's known as the ABC test, which is one of the more widely utilized tests throughout the country. The ABC test looks at 3 factors to determining your employee classification for your wage and hour purposes. The burden is on the employer to be able to demonstrate that the worker is properly classified as an independent contractor. It is not on the government entity or the taxing authority to meet that burden. It's an affirmative burden that rests with us as an employer. So we want to be sure that when we're engaging individuals to perform labor for us, we're analyzing what they're doing and we're properly classifying them. The first test that we look at is, has the individual been and will they continue to be free from the employer's control and direction over the performance of services? What does that mean? That means that when the person is, whatever they're retained to do, whatever job they're retained to do, are they following the direction of the owner? Are they following the direction of a manager? Or are they told, you need to get X done, and the manner, the tools, and the time that you use to get it done is within your complete discretion? If we can satisfy those criteria, then the first box has been checked off. The next question is whether the work is outside the usual course of business for such services performed, or whether the work is performed outside of the normal location of the business's operations. So what's work outside of the course of business? Using the restaurant industry as an example, if we would be very difficult to establish that we retained an outside independent contractor to be our chef or food preparation staff, because preparation of food is the key function of the restaurant industry. And so obviously that's a very extreme example, but it's to gain an understanding as to what we're talking about when you say outside of the course of business. A bartender, part of our regular industry, not somebody we could say is an independent contractor, and obviously our servers. The next question, and this is one where particularly in our gig economy and in we see a lot more controversy or dispute over what's this third area, that the individual is customarily engaged in an independent established trade, occupation, profession, or business. He individually is customarily engaged in an independent established trade. So normally and traditionally, if independent contractors were service people who came in to do work when needed, individuals who we retained to support our marketing. However, as services that may have been traditionally done in-house are outsourced to outside entities, and with that, we're giving up control. The scope of what falls into the independently established trade has been expanded because it's recognized that more people are working as their own entrepreneur and are supporting multiple businesses and providing a service. So we've seen there be disputes over this. Certainly, the government has looked to restrict that and constrain it because they want to keep more workers labeled as employees as opposed to independent contractors. But there are opportunities to classify individuals who are performing services for your business as an independent contractor, even if they were performing a service that had been traditionally done in-house. If we're truly able to satisfy those first two criteria, which are showing they're free from control and direction, and that the task that they're performing is not essential to the service to the purpose of our enterprise. Gary's going to talk about I say recent because it seems like it, but it's in 2015 already. It can't.
Yeah, it's hard to believe that much time has gone by. But it's a watershed case, meaning that it's very important. It kind of sets the standard going forward. So it's Hargrove versus Sleepy's. Most of you know that Sleepy's is a mattress company, and they had employees, but classified as independent contractors, driving around delivering mattresses in a truck. Okay, the truck had Sleepy's written on the side of it. But they were classified by Sleepy's as being independent contractors. And this went all the way up to the New Jersey Supreme Court. Actually got the Third Circuit Court of Appeals involved as well, because they wanted a certification as what is the law of New Jersey relative to this issue of independent contractor status. And the New Jersey Supreme Court came out with the presumption that all persons working for another are employees unless proven otherwise. Okay, so the presumption is that this person is an employee. And you should be aware of that because that's where you should start. And the presumption, this is what is the norm and the expectation. And if you are claiming that someone is an independent contractor, you're going to have to deal with the ABC test, which New Jersey sets the highest standard for the ABC because you have to satisfy all three prongs of the test. Now, I always tell people that the simplest way or simplest illustration of who is an independent contractor is simply to look at a plumber. If you have a leak in the house and you need that to be fixed, of course, unless you're very handy, you're going to call a person called a plumber who's licensed, and they're going to come, they're going to assess the problem. They're going to say, oh, this is broken or that needs to be replaced or whatever. They're going to make the assessment as to what has to be done. They bring their own tools to do the job. They might sell you a new fixture. And when they complete the whole thing, they go on to the next job, the next person that has called them on the telephone or emailed them and said, hey, I have a problem. Please come to my house or my place of business. That's a true independent contractor. So I know that this is not as much of an issue in this industry, but I'm sure there are times when you may have some of you classify in this manner. But always understand that there's one basic issue here, which is that employers, with all the impositions being made on them by governments, look for the easy out. They don't want the expense. They don't want the complexity. So they think that they have a magic wand. You're an independent contractor. Well, you're going to find out the hard way in many ways that that's not the way it works. And it can only be a legal determination that has to be thoughtful and informed in order to make those assessments. So there are probably not too many instances where you have independent contractors you may be dealing with. We cite a few here on the screen, but ultimately you should at least be aware of the fact that this is an issue, and it goes right back to are these people, what's their status as employees? Okay. So Brent, I think you're going to do the next one.
So Gary touched on this earlier. Up until recently, particularly with the ACA, whether or not somebody was full-time or part-time really was more of an internal issue as to whether or not they were eligible for certain benefits maybe offered by the employer. But now with ACA designating 30 hours a week as full-time for purposes of medical insurance, and that's now not just a plan document issue, but that's now a federal regulation, we need to be sure that we're properly tracking the all hours worked, because that not only do we have an obligation to do that for payment, but we need to know who is eligible for benefits, because these employees now have a legal right to it if it's offered. They have a right to it if they meet that criteria. One thing that can be that I think may come up in your industry more than the full-time, part-time issue is seasonal temporary employees. Oftentimes employers think of seasonal and temporary employees as sort of a different class of employee. And certainly we as an employer, we can say we're going to offer X benefit to seasonals. We're going to offer X benefit to full-time, to part-time. Our permanent staff, we're going to pay at a higher rate. Of course, so it has to be above minimum wage, but often what we have to recognize is that seasonal and temporary employees are still protected by the wage and hour laws, and that there's no relief from the wage payment components of that, from the overtime components of that, just because they aren't permanent employees. And so while we were able to break them down into different categories, we need to ensure that we're treating them and paying them and tracking their hours the same as we would for our permanent staff.
Let me just jump in for a second on that as well, because the restaurant industry in New Jersey has seasonal employees because of the shore business, which of course is totally seasonal, or at least in many instances is seasonal. And then also you have child labor, which often younger persons often will work, especially in the summer, work in a restaurant. And there are special rules that apply to them in terms of wages and hours and everything else like that. So knowing, who is your employee and what are the special rules that may apply to them, it's important that we always be cognizant of the differences. So in any event, and by the way, one other thing is when it comes to the ACA says 30 hours, but I find that health insurance, they typically will set the bar at 25 hours just to be on the safe side. So you have to look at your contract, whether it be your contract of insurance for medical insurance or other contracts for that matter, and be aware of what the requirements are. And one of the requirements under your typical medical insurance plan in New Jersey is that you cover all employees that work 25 hours or more a week. So understand that there's always a lot of things that flow from the proper assessment of the nature of the employment, the type of employee that you're looking at. Okay, so we're going to talk about exemptions now. And as I explained before, this goes to whether or not these persons are paid overtime or not. And Brent, I think you're going to take that, right?
So we're going to start with the rule that everybody's entitled to overtime unless they're not. So we start and we say, everybody that works for us, they're overtime, they're eligible, and then we analyze them individually by position, by task, by how they're paid to determine whether or not they fall into the exemptions. There are around 4 exemptions. We have 3 listed. The 4th is a technical, and the 3rd that's on ours isn't really going to be applicable to your industry. But when we analyze exemptions, we're looking at two key criteria. How much is the employee paid? And then along with that, how are they paid? And 2, what are their responsibilities? What are their duties? Oftentimes we see employers who end up in difficult situations as a result of trying to squeeze somebody into one of the exemption categories, whether it be executive or administrative. So first, we begin with the executive exemption. This is an employee who has to be compensated on a salary basis. And when we say salary, we don't just mean that they're not paid on an hourly rate. Salary also means that your rate, your weekly or biweekly pay, isn't reduced if you take a day off, if you take half a day off. It isn't reduced if you take if your performance isn't considered up to a certain level by your employer for that pay period. So the salary has to be an amount of money that you're guaranteed to be paid during that pay period. The second we turn to are the duties. And so this individual, to fit into the executive category, must be managing the business as a whole, not just individuals. So it would be, not a supervisor. This isn't a supervisor exemption. This is somebody who would be responsible for overseeing potentially, depending on the size, an entire location, or managing multiple locations. They have to have direct supervision, which in the restaurant industry usually is not an issue. There's usually significant supervision up and down the chain of command. And then the employee also has to have the authority to take action on behalf of the entity, whether that's hiring, whether it's promoting, whether it's setting rates of wage, promotions, reviews. The individual has to have authority to take action over other employees and to manage the human labor of the business.
I'd like to just jump in for 1 second, Brent, a couple of things. One, if someone is exempt in terms of the law, you can destroy that exemption so that even if they might otherwise be exempt, if you do not act consistently with the nature of the exemption, for example, you dock someone's pay in a way that's not permitted, you can actually destroy the exemption and they would be back to being non-exempt and hourly employees. So you got to be careful with those kinds of things. Second, I've frequently over the years, when I've gone to a new restaurant client, gone to the kitchen and said, how many chefs do you have? And they will say, oh, we have 3 chefs. We have the head chef, we have the sous chef, we have this chef. And I say, well, how do you pay them? And they would just start telling me, well, we're paying them $800 a week or whatever. And do you pay them overtime? No. How many hours a week do they work? Oh, they probably work 80 hours a week. You got to be careful with these things because probably there's only one exempt person in that kitchen. Okay, probably. Not always, depending on the size of the restaurant, et cetera. But I think people make a lot of assumptions about this, which are incorrect, because they're not making an assumption. They're not making an assessment, which is really, really important because, as we'll talk about in a moment, there's a consequence to this. One other thing is that the nature of exemptions, although the state of New Jersey basically mimics the federal law on this, there are some differences between the federal definition and the state definition. So you got to be careful that you look at both in actuality to be sure that you're in the right spot. So,
and just for information here, the information we're providing today focuses on New Jersey law. One question that did come up, and I just want to clarify because it popped up here, was when I had said if somebody doesn't work, the question was, well, if they run out of paid time off, do we have to pay them not to come to work? No, not in that instance. If you've agreed to a certain amount of time, they have to provide the services. This is, when I say that it don't work, if the restaurant decides that, you know what, it's going to be, we know that this week coming up, based historically what's going on in the world and data we've seen, it's a slow time for us. We're going to shut down. We're going to reduce our hours. That person who we're claiming is an executive or manager, we can't reduce their compensation because we've decided to reduce the hours that we're operating for operational reasons. That's when we say that, if there's less work, more work, if somebody's not working, if it's at the direction of the employer or as a result of the restaurant's decision to modify it or reduce its hours or days for a period of time. We oftentimes see this happen, and it's usually in good faith by employers, is people have the title of manager and they say, oh, well, they're a manager, they manage people. That could be true. But if that person, whether, if they're a front house manager, somebody who's a bar manager, if they don't have that independent authority to make decisions about what are we going to get for the bar? How are we going to manage the bar? They don't have the authority to make decisions about the staff. If there's somebody who above them has to really has the ultimate authority on hiring and firing and comp increases, then they're not exempt. And so just because we use that title manager and we place some authority with that individual, we don't have the ability to classify them as an exempt employee.
Brent, one other thing, and that is, and you're going to hear this again from a number of contexts. It's very important that you have job descriptions for those people that you are claiming are exempt. For example, there are other reasons for having job descriptions, which we'll get into. But what you can do with a job description, you can look at this definition of this is an executive and tie the job description right into what the words that appear on the screen. And by virtue of that, you are going to strengthen your case, because if you get a wage and hour audit and an auditor comes in and says, well, we're disputing whether this person's an executive, you can show them the job description. That is going to help establish a prima facie case, I think, of that person is exempt. So it's very important that you have job descriptions. And this little commercial, this is something we can help you with.
And we're going to talk about that also when we get to the end of it on our equal pay portion. Just moving along to keep it going. The next exemption is the administrative exemption. This, in your industry, this would really apply to back office support. Where we see that this can sometimes be misapplied is individuals who do clerical work. Maybe they're doing accounts work. They could be called in charge. They could be said they're director of HR. They're the head of accounts or billing and accounting, and they monitor everything that comes in. They pay everything that goes out. They're handling the finances. They are responsible for an entire sector of or entire portion of the restaurant's operation. If they're earning, the minimum amount, which for New Jersey is $684, they're obviously performing office work. And if they're supervising some other individuals below them who might be, office clerks or office assistants, they've got the first three. Then we come to that last one, which is does their primary duty include the exercise of discretion and independent judgment? And it has to be with respect to matters of significance. It's not just, what kind of paper are we going to order for the printers, and, where are we getting the light bulbs from? And so often we see people who are in these maybe a human resource, an office manager, an accounts department role, who may have some people below them and who generally operate with sort of on their own, because whether they're very competent or they've been there for a long time, and they're classified now as an exempt employee, salaried exempt employee under the administrative exemption. But as Gary said, unless we can demonstrate, and it always helps when if it's in writing, that here are these persons' responsibilities under which they have to exercise that discretion, and they have the authority to act on behalf of the employer. If we can't check off that last box, then we're not going to be able to satisfy the administrative exemption criteria, and ultimately the employee would be eligible for overtime.
Thank you.
And then the last one we have is we said professional exemption. That's not applicable here. Sorry.
Okay, so now we're going to get into something that it was a very significant development in 2018, was then amplified in 2021, and that's the New Jersey wage theft law. This is a very important law. This is a significant law and threat to you as owners of a business, because if you fail to comply with the law when it comes to payment of wages, this is they've upped the ante. Now we're talking about potentially a criminal charge. Further, it exposes the owners of the enterprise to personal liability, and the consequence of noncompliance is very severe. So we'll talk about this. Let's start though with two of the basics, which is the New Jersey wage and hour law, which we've in essence been talking about, because we've told you have to keep track of all hours worked. You have to set a pay rate that may not be less than the minimum wage, and of course, caveat in the restaurant industry, we have a person called a tipped employee, but what we're paying them, if we're paying them $5.13 an hour, is not below the minimum wage, because the other part of that requirement is they must get tips that at least equal $7.87, so they make $13 or better. So we're subject to the wage and hour laws. But then there's a second law, which is the New Jersey wage payment law. And this is an important law. And I brought a copy of this. This is from the Department of Labor in New Jersey. Okay. And this is a little handout. I should hold it up like this. This is a handout. And ultimately, it's a poster. So I'll just digress for a moment. There are 1 million posters because of all the laws that you're supposed to display. And by the way, one of the first things I do when I go into a new client, show me your posters. Show me where they are. And hopefully they have them. Sometimes they don't. But even if they do have them, they're often out of date. So it's very important that on a yearly basis, you check those and make sure that they're current. And you're supposed to put them in a place where it's likely to be seen, typically near a time clock, as an example. So with this little handout, which is it's the wage payment law, I'm just highlighted a few things here. First, employees leaving or terminating for any reason, including labor disputes, shall be paid all wages due not later than the regular pay day for the period in which termination occurred. This is one of the most classic examples of where you're going to get yourself into a lot of trouble. Something ends badly with an employee, you owe them money, and now because they stole from you or they didn't reimburse you for this or that, you think you can take that out of their final paycheck or not pay them at all. And I'm going to assure you that that is not the case. Okay, like it or not, if they've worked for you and they've put in the time, you have to pay them for that. You don't like what they did, you can sue them. Of course, you're not going to do that in most instances, but you may not withhold the final paycheck. That is the sacred cow. You're making a big mistake if you engage in that type of behavior. Okay, so the other thing that I highlighted here were a couple other things. One is no deduction shall be made from the employee's wages, except, and there are a few exceptions. Generally speaking, the most common one, of course, are deductions for payment of premiums and that sort of thing. Health insurance, contributions to a 401k plan or other pension plan. But generally speaking, you can't take money out of a wage, even if the employee owes you money. Let's say you lent them money, which is usually, as in my estimation, a foolish thing for you to do. But and you should have a promissory note and provide that if you have to sue them to recover this in a court, you can recover attorney's fees and other costs of collection. That's what you should do. Don't take it out of their paycheck. You're just going to get yourself into trouble and be treated like a criminal. And in fact, will be deemed to be a criminal. And then this is the kind of the 10 commandments. All employers shall notify the employees at the time of hiring the rate of pay and regular pay day. That's a shall. That's not optional. Notify the employees of changes in pay rates or pay days prior to the changes. Furnish each employee with a statement of deductions each pay period. Make and keep records of employees, including wages and hours, and make such records available for inspection. And that's again, too often I've seen where the Department of Labor, because they've had a complaint, comes in and now the employer is not able to produce the records to substantiate what they've done. Big mistake. And if you knowingly and willfully violate this law, you're going to be guilty of a misdemeanor and can be fined up to $1,000. Okay, well, that sounds serious. However, this wage theft law is far more serious. Okay, so let me see. Do we have some? Okay, yes. Okay, so the Wage Theft Act added a lot of heft to the requirements of the law. And one of the things that I think that we should understand, okay, we just went through the wage payment law. Those are the no-nos. You can't do those. However, now there's a reason why we're talking about classification, because if you misclassify an employee, now you are potentially a criminal. Okay, potentially a criminal. And so you may say, well, I didn't intend to hurt this person. I just didn't understand. I didn't, because this is a legal thing and I'm not a lawyer. Well, that's too bad. The bottom line is you're responsible for compliance, and you should talk to people like us. Again, another ad. to help you because if you make a mistake in this area, they've really escalated the consequence. So this is wage theft. It's defined to be the unlawful practice of employers not paying their employees in full for the work they perform. And there are many ways that employers may violate the law, including not paying for all hours worked, not paying the minimum wage, withholding the employee's last paycheck, withholding a tipped employee's tips, or otherwise not paying a worker in accordance with the many applicable laws. Now, misclassification will result in not only a violation of law, and constitute wage theft, but it could be up to a D felony, which means you're going to go to jail, and you're not going to go for 10 days. A felony is typically more than a year, and so what the state of New Jersey is telling you is that we're serious about this, and so therefore you better really know what you're doing and do it right. Now, employers who've been convicted of violating the wage theft law on 2 or more occasions are guilty of a pattern of wage non-payment, which is a crime in the 3rd degree, and a conviction of the crime in the 3rd degree can result in a prison sentence of 3 to 5 years and fines up to $15,000 or both. And by the way, we're talking about personal liability. Your company's not going to jail. You're going to go to jail. Okay, so this is, again, all I can say is it's very serious. Also, they've thrown some blood in the water and the sharks are circling. So plaintiffs' lawyers are encouraged to bring civil actions against employers and may recover attorney's fees and liquidated damages of 200% of the unpaid wages. So you're going to pay all the unpaid wages plus attorney's fees and a liquidated or punitive damage of 200% of that amount. So this can be very damaging. And by the way, even if you have employment practice insurance, although it might provide a defense of the case, depends on your policy. You may want to ask your insurance agent about that. The truth of the matter is that you're not going to have insurance to pay these things in terms of these wages. There's no insurance that pays for your wages that you owe to an employee. Now, liquidated damages can be avoided for a first-time violation, provided you correct everything. First, that you acted in good faith, that you had reasonable grounds to believe that you were doing the right thing, and that you acknowledge the violation, pay the wages owed within 30 days. Okay. Now, one of the things they also did was they extended the statute of limitations. It used to be 2 years for under New Jersey law, up to 3 under federal law. But now New Jersey says you can go back 6 years. And so, and here's the other thing that's bad news is that generally speaking, I find that when an employer does something incorrectly, they don't just do it for one employee, they do it for everybody. Okay. So in a wage and hour suit, and plaintiffs' lawyers can maintain what is called, well, you're familiar with the term class action, or another alternative to that is collective action. In either case, you don't just have one plaintiff, you might have 30. And if you fail to defend what you've done, now you have 30 times the damages to be paid, which, needless to say, is a disaster. And I remind you that you're obliged when someone's hired and starts to give them this abstract that I was reading from before, and make sure that they're informed on their rights under the wage laws. Also, another aspect of this, there's a presumption that if you take an adverse action against an employee within 90 days of them filing a wage complaint, there's a presumption that your action was retaliatory, which will also give rise to punitive damages. And by the way, retaliation is a recurring theme in a lot of our laws, and employment laws and civil rights laws, because, for example, workplace harassment, you take an action and then there's an adverse action. It may give rise to a presumption of retaliation. That will give rise to punitive damages. So it's very important that even though you may be upset with someone for filing a complaint, you may not retaliate against them for doing so. They have every right to do that. Okay, so let's be mindful of that. Okay, so now that was 2018. Now in 2021, there were a few things added to the law. And I think the most important one is that the Department of Labor is now authorized to do 2 things. One, historically, I don't want to get into the way the Administrative Procedures Act. It's too complex, and we don't have the time. But the Department of Labor can now go to Superior Court and seek an injunction if you're doing something incorrectly. They can enjoin you, stop you dead in your tracks. Not only that, they can get a stop work order that extends across all your work sites in places of business. So you may be doing it here in this site, but you may have 7 of those. They can put a stop work order for all 7, and the employees must be paid for up to 10 days of work loss due to this stop work order. And they can impose up to $5,000 in civil penalties for each day that you're operating in violation of the stop work order. So this is very serious, and they can go and sue like a plaintiff. They can have the same rights as a plaintiff, including getting attorney's fees and punitive damages and everything else like that. So very serious. And we haven't seen a lot of this yet because of pandemic, but I predict you're going to see a lot of that in the future. And is this you, Brent?
The compliance, I'll jump in. So, this is just sort of a checklist of the items that Gary's talked about in detail here. How do we avoid the coming under being an action from the Department of Labor? How do we avoid a class action suit from a group of former and current employees? First thing, everything needs to be in writing. Job descriptions need to be in writing. We need to have documents that reflect what the employees are paid, what their position is. We need to make sure that we're tracking all of their time, that we're tracking how they're paid, that we're providing them documents that with their paycheck that show all deductions, show how they've been paid. And we need to make sure our classifications are correct. And we want to document that. Is the employee exempt, not exempt? Is the person an employee? If not, what's the basis that we're taking that position? Oftentimes we see in the litigation end of this that employers' failure to have documentation causes there to be per se liability for some of this, and where the employer had no intent and may have to not pay employees correctly and may have been compliant 95% of the time, but we have 5% non-compliance, and then all of a sudden we don't have any of this documentation that we're required to produce. It creates a field day for plaintiffs' lawyers and can take what was a minimal non-payment of money and turn it into an expensive defense, an expensive settlement, or litigation.
Brent, I think we need to speed up here.
Yep.
We're running out of time, and I hope we can take a couple of questions, but let's go on to the tipped employees. And I would just say that hopefully people, in view of the fact they're in the industry, know the rules for tipped employees. But I would remind you that it's your job when you hire someone to inform them that they're going to be characterized as a tipped employee. And here are the rules for the tipped employees. So I would say if you don't have a policy in writing concerning tipped employment rules, you'd be wise to have one and hand it out when you hire people. And also, just keep one thing in mind here. Tips, they have to be, this is a voluntary payment. If you're imposing one, like 6 or more patrons, you impose a service charge. Always remember, that's a service charge, has a different set of rules, and it's not a tip. And if you have someone working long enough in that context, then understand their hourly rate for that time spent it's going to be different than a tipped employee. You're going to have to be paying them at least the minimum wage for the time that they're working under that service charge. So please keep that in mind. So what else do we want to do here?
Just quickly with dual jobs, this is again, this could come up where you have an employee who may be filling 2 different tasks for you, 2 different roles, and they start the day at lunchtime doing one and then transfer to another as the day goes on, or if somebody calls out and you have to fill a shift. When that happens, you need to make sure, one, that we're documenting for that period of time that there was a change in job, particularly if it went from a tip to a non-tip position, and that we're ensuring that the rate of pay, the hourly rate of pay, is appropriate for the tasks that they're performing. And that's just paperwork, having your managers do the paperwork as the need comes up and you're reassigning employees.
Okay. Now, I'm not going to, by the way, that's a dual job. That's the federal government that came out with that. And you should be aware that the state of New Jersey may not agree with that. On tip pooling, no, I want to talk about credit charges just for a second. Although the federal government allows you to deduct the service charge that the credit card company charges and take that share of it out from the employee, state law does not. They changed that. They have a regulation on that. You cannot do that. Okay, so last thing is this Diane B. Allen Equal Pay Act. This is very, very important, and you probably heard nothing about this. But the bottom line is they changed the whole paradigm of equal pay in this way. That what they talk about, instead of equal pay for equal employment or job category, now they talk about, in this law, substantially similar work. Now that opens up a big door for all kinds of claims of discrimination, because let's say you have two categories, a waiter, let's say, and waitress. Okay, first of all, those titles carry with it a gender connotation. Now, let's say in your restaurant, because historically you've been in business forever, and the waiters get X, consideration for what they do, and the waitress gets something less than that. Well, that's going to be a big problem. Okay, you need to look at all your job titles and determine, what is the nature of this work, and if it's similar in nature, it's absolutely required that you pay them equally under that circumstance. Brent, if you have anything?
Yeah, I mean, and titles don't matter. It's the work that's being performed. So if you have somebody you give the title a manager to, and they're supervising, whether it be the bar or part of the restaurant, and they have employees under them, and we have somebody else who we don't give that title to, but maybe they're managing our wait staff, and we call them maybe a head waiter, but they have responsibility that's on par with somebody else. We're not going to look at those titles. We're going to look at the government, or the plaintiff's lawyers are going to look at, what do these people do every day? What are their responsibilities, and what is their authority, and how are they compensated? And so titles have gone out the window at this point.
So I would say job descriptions, absolutely essential. Look behind the job title as well, because it may have a sexist, gender-based connotation that would be improper. This all comes under the law against discrimination. Okay, so and the law against discrimination normally had a 2-year statute of limitations. You can, once again, you go back 6 years with this, provided the last act of discrimination occurred in the last 2 years. And by the way, every time you issue a paycheck and it's subject to this kind of discrimination, it's viewed to be a new violation. So you're really not going to get out from under that. And I would just urge you to look at this carefully and perhaps reconstruct your titles, and the way that you pay people, and for what you pay them for what types of work. And you haven't seen a lot of this yet because the pandemic took all of our attention away from this. But ultimately, you're going to see a lot of lawsuits in this area. And again, the attorney's fees is awarded, punitive damages, et cetera. You're looking at what can be a world of hurt. And again, a collective action, because it's probably going to affect a whole group of people. So this will ultimately have a very serious consequence if you're not mindful of what the law requires of you. And I think that's about it.
You want to start going through some of these questions?
Yeah.
All right, so I'll read them off, and Gary and I will chime in on it. So the first question is, where can we find a detailed list of what is considered and what is not considered tip producing work? So interestingly, right at the December 28th of 2021, talk about the end of the year, the Federal Department of Labor issued revised rules that sort of address this issue. And there's the standard, they provide a standard, but there's no, and they provide examples, but there's no list that says this is the list of all tip producing work. The definition that they use in the federal regulations is tip producing work as work that provides service to customers for which tipped employees receive tips. Examples of tip producing work are taking orders, serving food and drinks, making drinks at a bar. And then there's directly supporting work. And work is generally considered directly supporting if it is performed in preparation or otherwise assists tip producing customer service work. And then they have
Let me just jump in. It's always been that you couldn't spend more than 20% of your time, which is roughly 1 day a week, doing what waiters and waitresses do, setups on a table, for example, putting the silverware, the plates, etc. They've added a few other concepts here. One of them being, is this a tip producing, support tip producing work, but they also the federal government put a 30-minute limitation. You can't spend more than 30 minutes doing this no matter what. So that's a whole new set of rules. So
it's 30 continuous minutes,
right?
So that you don't have to have a stop clock on your people.
Right.
And so that the next question came up with that is that if a server is waiting 30 minutes for a table, are they allowed to call? Oh, no, we scan down there. So next we have an on the clock question. If a server is waiting 30 minutes for a table, are they allowed to clock out and voluntarily wait around to see if it gets busy again and clock back in to start working? That could be a very dangerous situation. The first thing is there's going to be a presumption that you told them to stay there, unless
well, here's the thing: is the worker free to do what they want to do? Okay, with their time. Okay, because a lot of times you have on-call kinds of situations. Now, if you say to the server, hey, you can go downtown and go shopping for the next 2 hours, come back in 2 hours, and resume your activities. That's one thing. But if you're saying, hey, go sit in the back room and just read a book because we're going to need you maybe in a half an hour, forget that. That's not going to work.
And if the server says, oh, I want to just stay around here and wait, again, there's going to be a presumption that you told them to. And the other issue is, God forbid they lift one finger to help one person do something, whether it's, move boxes, stack the bar, help with a table. They've now performed labor for you, and that's work.
Or if they get terminated and they go down to the labor department, and now they say, I didn't agree to that. I was coerced into accepting. I really didn't want to say yes, but it's the inherent coercive authority of the employer made me go along with that.
So Gary, our next question is, how is the tip credit factored into overtime?
Oh, okay. So this is the way it works: is that you have a tip credit, okay, $5.13. Okay, and if you supplement if you work in a straight time rate, it's $7.87 plus the $5.13 is $13. That's pretty simple. When you get into overtime, what you do is you take the overtime rate. It's $13 because these people are basically minimum wage workers. So you take your 13 times 1.5. Okay, that gives you your overtime rate. Now you take the same tip credit off of that. Okay, so the $5.13, which was the $7.87. I'm sorry, the $7.87 is subtracted from the overtime rate, and you have to pay the difference. And that's basically how you pay overtime to a tip worker.
Next question here is one where good tensions can get us in trouble. What do we do when a customer specifically requests that half of their very large tip is to be shared with the chefs? How should that be addressed, given that the chefs back of the house staff are not tipped employees? So here you think this is great. They were so happy with what our service and what we provided them that they want to spread the money around. Number one rule of tips: the tip is the property of the tipped employee, and it is not the property of the employer. So as an employer, outside of an approved compliant tip pool, we can't direct where a tip to go to somebody else, even if it's not management, even if it's to another employee.
And by the way, out of the goodness of their heart, the patron may have said, "Hey, spread it around," but honestly, they're not the Uncle Sam. Okay, so we have sovereigns, Governor Murphy and President Biden. They tell us what we can do and what we can't do. And ultimately, when you talk about back of the house, that's a no-no. If they're also management, that's even worse. Okay, can't split a tip with a management. So you're violating a few rules there. So say thank you, but I'm sorry, we can't do it that way.
Next question: as a seasonal business, is there a minimum to be paid to an hourly paid exempt employee in the off season? So I guess in a seasonal business, if we have somebody who's a legitimate exempt hourly employee, and how do we treat them in the off season? You might want to follow up with a little more on that one because there's some more facts there that
Here's what I would say basically. Look, if that person's a seasonal employee, generally speaking, the understanding is, hey, we start May 1 and we stay open till September 30. Okay, so that's the season. And at the end of the season, the work stops and generally no one gets paid, I don't think. However, if you have a gifted person whose services you value, you may say, hey, look, I'm going to pay you some amount over the winter to help you, wait until the start of the next season, or maybe you want that person to help you during the winter, maybe in a different role as opposed to what they do in the summer. But ultimately, you might be able to keep them on that basis. But that's kind of a person-to-person, place-to-place kind of differentiation.
Yeah, and because even if in a limited window of operation, if you're performing exempt work and you meet the exempt criteria, it doesn't matter that it's for a 6-month period. It's all still based on the work and the wages. So it's still an objective test there. All right. Next question: if a salaried manager has cash missing, such as a full day deposit from their work shift, is the employee allowed to pay back the missing funds?
No. If in fact that's the case, that there's missing funds, you're going to have to decide, do I trust this person in the first instance? And even if I trust them, if they're that incompetent, do I want to continue to employ them? But that's your issue. But you can't make them pay it back. If they break some china on the floor, drop some glasses, you can't make them pay for that. Again, that they may be Butterfingers, but you're going to pay for the breakage. And now you just have to decide, can I afford to employ this person if they're going to be dropping things?
Is there any further obligation on an employer to pay staff beyond paying out their available New Jersey earned sick leave hours in the case of required quarantine for COVID? In the state of New Jersey, the answer is no, but that varies from state to state. The federal legislation that provided the additional time sunset over a year ago at this point.
Yeah.
And so unless you as an employer have a policy that provides for additional time, you want to make sure we apply our policies uniformly. But from the state of New Jersey, it's earned sick leave would be all they would be entitled to.
Right, and you might have a policy, for example, of paid time off in addition to the sick time. And if you have a policy for paid time off, they might be able to take that, again, depending on how you've written your policy.
This is a good one. We often have loaned employees money and they sign a promissory note where the promissory note specifies that payments are deducted from their paycheck. Is that legal? We cannot give, are we allowed to give an advance on future paychecks?
I would just say, as a general rule, do not loan your employees money. That's a bad idea because it gets very complicated. However, there is an exception under the no deduction shall be made. And it says that you're permitted. Here's the exception: purchase of company products or employer loans in accordance with periodic payment schedule contained in the original purchase or loan agreement. So if you have a written loan agreement and you provide for periodic payments, it can be, and it's authorized explicitly that I'm authorizing you to deduct these payments from my paycheck, you can do that.
And then the second part of that was,
let me just say, Alyssa, you're looking a little nervous, and if we're going over time and we can't continue, just give us the sign, but we're happy to continue.
You're good until for about 10 more minutes.
Okay, good.
Yeah.
The next question was, and then just following up on that was, what about an advance on a future paycheck?
That's a loan, and it's not a good idea.
But the same would apply, that you would.
Well, again, if you have a written agreement,
yes,
and they are authorizing something to be deducted,
it can't be a verbal. It can't be, hey, boss, can you front me $500 until my next paycheck?
Exactly.
If that's the conversation out of the goodness of your heart, then if you take that money out of their paycheck without a written document, you violated the.
You're going to run down to the Labor Department, and just keep in mind we have a thing called wage theft, and that is serious. So this is not to be done lightly. You have to really think these things out, or else you're going to get yourself into a lot of trouble.
If a manager who gets paid bonuses leaves or is terminated, are you required to pay out their pending bonuses for time worked or just their salary? So this is going to come down to, do you have a written contract with that employee? And
Or a bonus, you might have a bonus plan.
or bonus.
And what does the bonus plan say? But it should be in writing, as you say.
And anytime you have an agreement like that, you always want to make sure that it states not when is the bonus earned and due, because we may, if let's say you base it monthly or quarterly, you could say, well, we need to, in your plan document, it would be very common to say, oh, we have to reconcile the finances for it. So bonuses aren't payable and earned until 30 days after the close of the period, whether it's the month or the quarter. And so you control the outcome there. The employer has the ability to say, and now it's important that it's a bonus. If it's a commission, there's different rules. But bonuses are generally discretionary, and it depends on how you phrase it. So you can write your bonus plan in such a way that you're protected.
You can protect yourself, but always keep in mind that a commission or a bonus is a form of a wage. It is a wage, and therefore subject to wage payment rules and everything else. So that's why it's very important that you be explicit as to the rules that apply in terms of when is it earned, when is it paid, and how is it earned.
All right, I think actually last one, and we've got coming in right under the radar here, right under the gun. What's the industry standard or best practice for salaried on-site 24-hour on-call employees? How do you structure the wages, e.g. an apartment building super or an innkeeper that lives on site? So we'll talk. They're two separate. Professions there, or two separate employee designations. So with a building super, the individual, and assuming they even live there, right? They're going to have hours where they're expected to perform their work, right? Their tasks of maintaining the building, doing regular maintenance, doing the landscaping, the job of the super. And then there comes the time where that individual is it may be called upon at night or on a weekend or outside of their regularly agreed upon workday to perform additional work, whether it's a pipe break, whether an outlet goes, something, whatever emergency comes up. So how this is governed first says, do we require that our super be on site for a certain period of time when outside of their regular hours so they can respond to these emergencies? If the answer to that is yes, then they're in a period of on-call pay. If the answer to that is no, and that they're allowed to go use their time as they like, they just, once they receive the call, they understand that they'll be there within a certain period of time. Then when they're called in and they called in from the period they stop living their life till they get there and start doing the work and finish it and go back to their personal life, they're entitled to compensation. And it could be, depending on the employee, it could be overtime compensation as well.
Yeah, are they exempt or non-exempt, for example, is going to make a big difference in the answer to that question. Okay, and also, they're actually, I actually had a case where it was an adult home. I think it was for adults that had been in accidents and were brain damaged and needed supervision and care 24 hours a day, 7 days a week. And there was a person working in that home who had to be available at all times of the night. And literally, in that instance, you have to pay that person, even if they're sleeping, because the requirements of the job. So it really can vary quite a bit. But I think that ultimately, to some degree, it comes down to this. Two things. One, are they exempt or non-exempt? And two, are they under your direction and control? If they're under your direction and control, meaning they have a beeper or something that where they have to respond to that, you may have an all on-call rate, which could be a different. By the way, when you have titles and different types of work that are being performed, you can pay different pay rates, provided you have a job description and you make clear, okay, if you're doing this type of work, this is your pay rate. If you're doing that type of work, this is your pay rate. And if you then get into overtime, it gets very interesting. Do you blend the rates? They have options and how to do that as well. But bottom line is that you really have to look at to what degree is this super who resides in your building And by the way, keep in mind that the rent that the free rent that they're getting is a factor of their pay rate. So when you're figuring out their overtime rate, just make sure you add that in accordance with the law as to how you characterize that and how you include that. So it's an interesting question. It gets a little complicated, but as always, there's a solution to what are we supposed to do?
One last one came in.
Oh, okay.
We're closing our restaurant for vacation. We are paying our employees for the time we are closed based on their scheduled hours and hourly rate. We normally pay our servers $5.13 per hour, and we are wondering if paying them vacation pay at $13 per hour for their normal schedule is legal.
So what's the question?
I think the question is, if we're going to pay employees when they're not working, is there a legal amount that we're obligated to pay them?
Okay, so you're paying them for not working.
Yes.
Now the question becomes, are you under some obligation to pay them as opposed to not? But in all instances, I think you have to pay at least the minimum wage if you're going to pay them. And if you're going to classify this as vacation, it's not work time, but I would think that, you can't pay them $5.13. I mean, that presumes a tip is supplementing that.
Yes.
So I would say if you're going to pay them, you have to pay them 13. And by the way, that got into when that new sick leave law first was imposed. There was a whole issue as to, okay, what are we supposed to pay someone who is a tipped employee who is out sick today and is going to be paid for 8 hours? And at first, the Department of Labor, typically trying to legislate, said you have to pay them what they normally earn on average, which is baloney, by the way. And you have to pay them they're a minimum wage worker. You pay them the minimum wage on sick time, for example. So that I think that's the answer to that.
I agree.
Yeah. Okay.
All right.
All right. Those are all the questions.
That sounds good. You guys really got through that. I'm amazed. I thought it was never going to be able to be answered in the time frame. So thank you. Thank you very much. Thank you all. Thank you all again for participating. I just want to mention that we did record this and we will be providing a link. So we'll have the link on our website, but you may want to just reach out to us if you have any further questions, and we can always get them over to Brent and Gary for in the future as well. So thanks so much, everybody. And thank you so much, Gary and Brent. This was fascinating. Have a great day.
I enjoyed it. Thank you.
Thank you, guys. Thanks, everyone.
Bye-bye now.